a new First Amendment case, Hines versus Purdue.
This is Dr. David Shine, and welcome to Business Law 101.
Dr. Ronald S. Hines is a retired and physically disabled veterinarian licensed in Texas. He was providing online pet care advice without physically examining the animals. The problem here was that Texas law requires veterinarians to establish a veterinarian client-patient relationship through an in-person examination or a visit to the premises where the animal is kept. Therefore, Dr. Hines was penalized for violating this requirement, receiving probation, a fine, and was required to retake part of the veterinarian's licensing exam. He did not take this punishment lying down. He challenged the law on the First Amendment grounds, arguing that it unconstitutionally restricted his speech. The United States District Court for the Southern District of Texas initially dismissed Dr. Hines' First Amendment claim. However, he was persistent and appealed to the U.S. Fifth Circuit Court of Appeals. The appeals court reversed and remanded the case back to the district court. The appeals court noted Supreme Court precedent regarding state actions that limited speech. On remand, the district court still granted summary judgment for the state, concluding that the law regulating Dr. Hines' speech in a content-neutral manner and survives something called intermediate scrutiny. This last term is a court doctrine related to evaluating rules and regulations of different legislative bodies. Dr. Hines, not giving up, again appealed this decision. In an interesting development, the Fifth Circuit determined that the physical examination requirement primarily regulated the content of Dr. Hines' speech rather than his conduct. The appeals court also concluded that the law was not narrowly tailored to serve the state's interest because it burdened more speech than necessary. So as applied to Dr. Hines, this was a content-based speech restriction that does not survive a different legal standard called strict scrutiny. Consequently, the Fifth Circuit reversed and awarded Dr. Hines his day in court under the First Amendment. In fact, a humorous aspect of this case was that the appeals court observation that humans could get medical advice through telehealth, but not animals under the Texas regulatory interpretation.